Aisha just joined us. Hi, Aisha. We have Aisha
Hello, how are you
Dunmore.
guys?
She's
Yeah, sorry, I had to mute my microphone there.
so she's an associate attorney here at the Cromie's Law Firm. I'm going to share my screen in just a moment. I think everyone's going to be kind of trickling in over the next few minutes. So please, if you have any questions while we're presenting, feel free to send via chat any questions you may have. But we will start that Q&A after Aisha presents.
All right. Well, first, I'd just like to say good afternoon to everyone. Thank you for joining us for our dispute resolutions webinar. Like Leigh said, I'm going to go ahead and go over the presentation that we have, and then we are going to go into a question and answer portion where you can feel free to ask any questions you'd like to, hopefully on topic, but if you have any questions that kind of deviate, that's perfectly fine as well. Again, my name is Aisha Dunmore. I have been a practicing attorney in Texas for about 8 years now. I've been in the construction industry for about 3 years. Prior to that, I was doing general litigation, so lots of breaches of contract, business litigation, commercial disputes, that kind of thing. So it all falls along the same lines. I have been doing dispute resolutions, whether it be arbitration or mediation, for the entirety of my career. So hopefully I will be able to give you guys some insight on the topic. And with that said, we can go ahead and get started. First, just a brief overview of dispute resolution. It's pretty self-explanatory. Anytime you are in a business transaction, especially in a construction transaction, whether you be an owner or a general contractor or a subcontractor, there are going to be disputes that come up. These disputes can be related to the scope of work, payment terms, what type of delays are acceptable or not acceptable. And it's really important to have an idea up front of how you're going to handle these disputes. Usually your contract is where you want to go to kind of determine how the dispute is going to be handled, but sometimes the contracts are silent. There are 4 different types of ways generally you're going to be handling a dispute, whether it be a construction related dispute or any type of commercial business dispute. You're going to have an informal resolution process, mediation, litigation, and then also arbitration. Those are the 4 different ways you can typically handle a dispute. And you kind of want to start with the informal dispute resolution. That's typically going to be your quickest and most cost-effective way. Now, when you're dealing with an informal dispute resolution, it is important that you have an attorney. And you're going to hear me say that throughout the entire webinar, the importance of being represented by an attorney. The issue with that is that you want to have complete resolution to a dispute. And so while it may not seem important to have an attorney in an informal setting, the reason to do so is so that way you absolutely have finality to that dispute. What you would hate to happen is you come to some sort of informal resolution with the other party, and then they back out, or things or terms are not followed exactly as you thought they were going to be. So that's the important part of having an attorney. Now with the informal dispute resolution, this is usually the first step. It's going to happen before any type of formal dispute resolution process, the formal ones being the litigation, mediation, and arbitration. In an informal dispute resolution, it generally consists of drafting demand letters. Your attorney will usually draft a demand letter, and that letter is going to outline what your problem is and what you feel you need to resolve this problem. Typically, this is going to be done via email exchange. Sometimes, you know, these letters are mailed out or certified mail. Usually that's just a formality. Everyone knows that we are all checking our emails a lot faster than we're waiting for the snail mail, so to speak. But during this process, the attorneys will engage in correspondence, whether it be formal letters or email. They'll basically outline each party's position. Each party will determine what they need in order to resolve the dispute. And hopefully, after a few correspondence back and forth, there will be some type of resolution. Once a resolution is reached, you know, that starts to turn into the lawyer protecting you and giving you that finality that I spoke of. Usually, once you resolve the dispute, you want to go ahead and get some mutual releases drafted. The benefit to that is now you're releasing any claims you may have had in the future for damages or, you know, different causes of action that would have been related to that dispute. For example, if you're having a dispute over the scope of work, and we determine, you know, that your scope is A, B, and C as opposed to, you know, A through E, you're going to want that in writing. You're going to want the other side to release their desire or their ability to come after you later for the pieces of the scope that you already determined weren't going to be in. And so if you don't have an attorney, a lot of times what'll happen is you may come to these agreements, but then later they may change their mind and you don't really have anything enforceable in writing to show, hey, look, we've already made this agreement and they've agreed to release our obligations to any further scope of work, you know, in that example. What's also important is anti-disparagement clauses and non-disclosure agreements. These may seem a little unnecessary, but what you'd hate to happen in today's day and age, as you know, we're online right now, and lots of times what will happen is people will leave Google reviews or Yelp reviews, or either that, just, in their networking, they may badmouth you to other people. You may feel as though you resolved the issue, but then at the end of the day, they're going to say, Joe is a really bad business guy. He didn't agree with us on the scope and we had to hire lawyers and it was a bunch of drama. And sometimes, that can be bad for your business. Everyone knows when you log online and you look at those reviews, they can be very damaging. So it is important when you resolve a dispute, again, to get that finality. You don't want anyone coming back, anyone complaining, anyone bad-mouthing one another based on the resolution that you believe you came to. So we go to the next slide, please, Lay. Thank you. So the next step in our dispute resolution discussion is going to be mediation. This is a very, very common solution. Mediation is not only done individually, but it's generally also done as a part of the litigation process. The whole purpose of mediation is for you to go seek an expert, a mediator who's been certified. Hopefully he's got some knowledge in your business area. You wouldn't want to take a banking dispute to someone who generally practices construction law. And you also don't want, a contracts guy just looking at your construction dispute who may have no idea, what these engineering reports require, or architects, or how rain and bad weather may affect a construction project site. So mediation is typically very successful. It does assist the parties in coming to an agreement. The major benefit of a mediation is that you've got the case in your hands. In some of these processes, the litigation process and the arbitration process, you don't have any choice in how the matter is resolved because it is being resolved by a third party. So here in mediation, you get your hands in the case and you get to agree on what the resolution is going to be, as opposed to having someone else look at the facts and tell you what's going on. Also, the one thing that it does mention in the slide is, I know I mentioned it's also a part of litigation. A lot of times they consider mediation your ticket to the judge and jury. And what that means in a litigation process is that you absolutely have the right to file suit, and then you proceed with the litigation process. But before you actually get to your day in court, that trial, whether it be by judge or jury, the court system 9 times out of 10 is going to require that the parties mediate the matter. And that is because mediation is very successful. And like I said before, it gives the parties an opportunity to come up with an agreement that's best for them, instead of leaving it up to a judge, a jury, or an arbitrator. Now, when you're in mediation itself, it seems a little scary, but it's much less informal than an arbitration or a litigation process. Usually it happens at the mediator's office. I've seen it happen also at one of the attorney's office. As long as the parties are not very contentious, that would work fine. So generally there is an opening statement. And in the opening statement, all of the parties come together in the same room, generally a conference room. You will have, one party with their attorney, you'll have the other party with their attorney as well, and then you'll have the mediator. So usually it's only about 5 people in the mediation. The mediator's job is to bring the parties to the middle, right? To come to a resolution in the middle. In this opening session, generally what happens is the plaintiff or one of the parties will begin to, very similar to the demand letter, state his position. Now, again, this is not something to be too concerned about. As long as you're represented by an attorney, you generally won't have to speak at the mediation. You just kind of sit back and let your attorney do his thing. And what that thing, consists of is expressing what your concerns are, expressing your position, and then also expressing your desires for the outcome of the mediation. Now, obviously, the opposing party will have the same opportunity to do so, and they will express their opinions and their feelings on the case as well. Now, you can imagine that sometimes once you've gotten to the point of mediation, sometimes it can be a result of litigation or it can be by agreement. But once you get to that point, sometimes the parties can be contentious. I mean, this is all surrounding a dispute in the very first place. So lots of times we will just opt out of the opening statement. The last thing we want is for people to be upset. And generally by that time, you already know what the other position is, right? You know what the other party wants, you know how they feel, and you just haven't been able to resolve it from that point. So either after the opening statement or, sans the opening statement, at that time, the parties will go into 2 separate rooms and the mediator just kind of goes in between the rooms. He'll start in room A, he'll talk to the parties, and he'll try to get a demand, very similar to the informal process. So, we'll say we want X, Y, and Z. And then the mediator will then leave the room, he'll go into the other room, and he'll have the same conversation with the other side. He'll let them know how you feel, what your points are, and he'll also communicate what you're willing to do or what you need in order to resolve the conflict. At that time, the other party will then go ahead and, express themselves as well. And so the mediator goes back and forth, generally half a day, sometimes if it's a bigger dispute, a full day. And at the end, generally there is a resolution. The mediator will be able to have the parties meet in the middle and come to a resolution. Now, the benefits of mediation, like I said, it is one of the most preferred methods of dispute resolution, is the parties are in control of what the settlement entails. In some situations, juries and judges, they generally only give monetary relief, meaning they'll put a number on your damages, and that's it. That's what you get to walk away with. Sometimes in a particular type of dispute, whether it be construction or other business, sometimes there's more things that can be done, right? Maybe we don't want money. Maybe we want you to come out and fix the problem that maybe your work created. Maybe we want a different type of solution that will require some future steps or future action by the other party. So those are the type of things people can come up with in a mediation. And the cost of mediation is also a benefit. It's generally split by the parties, and it's generally the most economical form of dispute resolution. You pay the mediator. Again, you're also going to have to pay your attorneys for their time. But at the end of the day, you're not going to come up with anywhere near the costs associated with the arbitration and the litigation process. And you still get all of those final documents like we discussed. You're going to have mutual releases. You may have anti-disparagement clauses or a non-disclosure clauses if that's something that you agreed upon. And the mediation, once it's settled, is binding, right? So you don't have to agree, but if you do agree, you can't come back later and say, oh, well, no, let's just start all over. It is binding, but it is a choice of the parties. Okay. So moving right along, we are now into litigation. Obviously my favorite because I'm an attorney, but I'm a little biased. So never mind that. Litigation is the American way to solve the disputes. It is your standard court system. It's what you see all the time on TV. The plaintiff files his petition, and that tells the court, hey, look, look what this guy did to me. These are my problems. These are my causes of action, and this is the resolution I want from the court. That is how you start the petition. And then the defendant is served. So the person you're having a problem with, the person you're suing, so to speak, you have to give them service of process. And that is typically having your authorized process server deliver the petition, right? And once that begins, now we have active litigation. So there are several steps to litigation. After you serve the documents to the defendant, they are required to file what's called an answer. And that answer is very similar to the plaintiff's petition. So in their answer, they have an opportunity to deny all of the allegations that you've made in your petition. And they also have an opportunity to bring any claims that they may have, right? So they can say, hey, no, look, this guy is wrong. And wait a minute, these are the things that he did bad. And these are the causes of action that I have against him and the reasons I want to collect. And this is how much I want as well. So, don't ever think when you start the litigation that you're not going to be countersued, so to speak. It's generally very common that, one party wants something, but the other party wants what they want as well. So litigation is going to be the most lengthy and the most expensive way to resolve a dispute. Television has glamorized it, but please don't think for 1 minute that it's exciting or thrilling or anything less than expensive and stressful because it really is. Now, obviously, this is our way that we resolve disputes here in the American system. And so it is going to be, I would say, your last resort for a dispute resolution, only because of the cost effectiveness. It's not very cost effective, unfortunately. You're going to spend a lot of attorney fees in the litigation process. There are lots of processes that are time consuming. And so once we have your answer, once we have your petition and we have your answer, next comes the discovery process, okay? So we don't play hide the ball in litigation, right? On TV, they may pull out something that's a surprise at the very last end, but that's not really reality. The litigation process is designed so each party can show their hand, so to speak, and you can see what you're facing. So in the discovery process, this is the process where your attorney gets to ask for documents. They get to ask for the production of documents and tangible items. They also get to ask for written answers to questions under oath. We call these written interrogatories. And then they also get to ask for requests for admissions. And so requests for admissions are very simple. They ask you to admit or deny facts in regards to the case. This helps the judge and jury because a lot of people don't understand, but juries only decide facts, right? They don't decide laws. And so all the facts that we can agree to before the case goes to jury, it basically saves you time, and it may actually eliminate the need for a jury at all. If there are no questions of facts and everyone agrees on what exactly happened, then the judge can answer the question of law and determine which way the case should go. So in the discovery process, this is going to be your, other than trial, right? This is your most expensive type of process. This is because it takes a long time to look through your case, to figure out the facts of your case, and to correspond that with the cause of action. Like, for example, if you're suing for breach of contract, there are certain elements that must be proven in order to prove a breach of contract. And so, was there a valid contract? Did all the parties assent to the contract? Was there consideration for the contract? These are all questions that have to be answered through the facts of the case. And in order to get that, we've got to send detailed discovery requests. Now, although I may handle 100 breach of contract cases a year, every case is individual in the facts. And so it's going to start from brand spanking new when I'm going in there and I'm drafting discovery requests. And so this not only is the request to the opposing side, but as you may be aware, the other side can then ask you questions as well. This whole process is designed, again, so each party shows their hand and it promotes settlement. The entire purpose of the litigation process, believe it or not, is not designed to get your case to trial. It's really designed so each party can see what's going on. They can have a full picture of how they stand in the decision or in the particular litigation, and then they can be forced to mediation, and from there decide, okay, look, this isn't looking too well for me, look at all this evidence they have, and they can go ahead and resolve it themselves. Generally, the discovery process is going to last all the way up until 30 days before trial, and this is because the courts want to allow all the parties enough time to produce any documentation or to retrieve any documentation that will be helpful to their case. Okay, so moving along, arbitration. Arbitration is going to be another form of dispute resolution where the problem, again, is out of your hands. You don't have control over what the final resolution is going to be. If it comes to expense, then arbitration would actually be before litigation. So as far as expense is concerned, the cheapest is going to be informal resolution. Then we've got mediation, then arbitration, and litigation is going to be the most expensive. That is not to discount the arbitration process because it is quite expensive. It just doesn't have the same length of time that the litigation process is going to have. And then also in arbitration, they may have some informal discovery process and exchange of documents, but it's not going to be anywhere as lengthy as the litigation process. Now, in the arbitration, it's kind of similar to a mediation where you go to the arbitrator's office, you may sit in separate rooms, you may go back and forth and discuss. I've also seen some arbitrators, they prefer to run their arbitration more like a court, and so everyone will be there and they'll present their cases individually. I have seen it operate both ways. I would say it is more common, though, for the arbitrator to have people put on their case as though it was a judge and jury. And so in an arbitration, what's important to remember is that the arbitrator has the final decision, right? So there's no judge, there's no jury, and there is no second swipe at the bat. In the litigation process, you have the appeals, right? So if you don't like what the judge said, you don't like what the jury decision came to, or you felt like procedurally something went wrong in the case, you can always appeal to a higher court and have an opportunity for that to be overturned. In an arbitration, you do not have that benefit. It's not appealable, it is binding, and it is final, okay? So typically, arbitration is going to be committed to before a dispute ever arises. Most parties don't, have a dispute and then say, okay, well, we have this problem, let's go arbitrate the matter. I've actually, in 8 years of practice, never seen it happen that way. Typically, what happens is parties agree contractually to arbitrate a matter before a dispute ever arises, right? And so that's really, really important because, like I said, you're waiving your rights to a judge, you're waiving your rights to a jury, you're waiving your right to an appeal, all of that, right? And so when you're looking at these contracts you're entering in a business transaction, you always want to take a look at the dispute resolution portion. In that portion, it's going to tell you, are all of the disputes subject to arbitration? Are some of the disputes subject to arbitration? I've seen contracts that are very lopsided. For example, when you have an owner who contracts with a general contractor, they can have lopsided contracts. The general contractor can say that, all disputes except for non-payment are subject to arbitration. And so what that essentially means is that you waive your right to a judge and jury, but as soon as you don't pay him, he's going to file suit right in court, and you can't even countersue, right? Because arbitration clauses have generally been held binding by all courts. Doesn't matter if you didn't read the contract, doesn't matter if you weren't aware of the dispute. It doesn't matter if it was 30 pages and it was, small in the corner. Unfortunately, arbitration contracts are very, very binding. Arbitration clauses on an invoice. You may just sign an invoice to say you received something. And at the bottom, it says any disputes subject to this, are hereby bound to arbitration. You've already waived your right to a judge and jury, right? And so, it's just really important to make sure that you look at your dispute resolution clauses and find out whether or not you're subject to arbitration. And it is a decision for you to make at that time. You know, like I said, arbitration is going to be an easier process than litigation, but it's just so much finality to it, and you only get one swing at the bat. I would absolutely prefer a dispute resolution clause that binds the parties to mediate in good faith prior to any arbitration, if an arbitration at all. Okay, so breaking down arbitration, like I stated, it is generally mandated through the contracts. That is pretty much the only way I've seen arbitration come up. Again, it means you waive your right to jury trial. So no matter what goes on in that contract, you know, you're pretty much wasting your money if you do try to go to court. I have seen people, you know, just sue anyway on the arbitration. I'm sorry, sue anyway on a contract that requires arbitration, but you're pretty much just asking the defendant to come in and throw your lawsuit out. There is what's called a motion to abate, and it allows the court to stop the lawsuit and force you to arbitration. And like I said, those motions are extremely successful. I mean, I would give them a 99% success rate. Again, if you agree to arbitration, unfortunately, you've agreed and there's no backing out. Like I stated before, it can be beneficial and detrimental. Arbitration is a lot easier than litigation. But, you know, some arbitrators are not lawyers. You know, a lot of arbitrators are, and most arbitrators do have experience. But unless you're going through an arbitration association, for example, AAA, the American Arbitration Association, your arbitrator, you know, may not be properly vetted. You could pick someone who's more friendly to an owner or more friendly to a general contractor. And so you also want to look to see if there is a designated forum in the dispute resolution clause. Lots of times in the contracts that I see, they're mandated through the AAA, which, if any association, I would definitely recommend the most. All right, well, thank you guys for listening to me ramble on about dispute resolution. I would be happy to answer any of your questions. I hope I was pretty thorough. I tried not to read off the slides. I know you guys got the slides already. So, you know, I just try to give you the best of my knowledge to the best of my ability. So Lay is going to take your questions, and then she's going to basically direct the questions to me to make sure everyone hears them clearly, I hear them clearly, and we get them all answered.
Perfect. Thank you so much. All right. I'm going to go right now to the chat. If anyone has any questions right now for Aisha, please feel free to send any question. Just keep it short as concise as you can in the chat. Or if you want to unmute yourself, we can also ask questions that way as well. I'm going to open up the floor. We definitely want to make sure you guys are getting all your answers. Thank you, Randall. We just got a question. Have you ever seen a contract saying all disputes are subject to mediation only?
No, I have never seen a contract that says that all disputes are subject to mediation only. And the primary reason for that, again, is because you don't have to make an agreement at mediation, right? And so if you have a contract that says all agreements are subject to mediation, well, then you don't have any resolution whatsoever. Parties can go to mediation. They can simply sit there all day and they can, you know, say no to everything that's proposed their way. And then you're stuck, right? Because if it's subject to mediation, arguably you've waived your right to sue and you've waived your right to arbitrate. Obviously, as an attorney, if my client was in a contract like that, I would argue to the court that, you know, there's no due process, that they don't have a real resolution, and that mediation has already been unsuccessful. But I would not recommend signing a contract like that, and I've absolutely never seen one.
Perfect. Thank you. We had a couple more questions while you were presenting from Paula. Let's see. All right. When do you have to send a notice of intent to breach contract?
Well, it all depends on your actual contract. Sometimes there may be a notice of intent to breach, a notice period in the contract. It may say, if you intend to breach, or if you fail to continue, or if you want to terminate, there may be some termination language in there that you have to provide 30 days notice. I've also seen contracts that do not permit termination without cause, that they offer a notice and cure period if you're going to terminate with cause. For example, if you have a contractor who's performing poorly, your contract may require that you send him a letter and tell him that he's performing poorly, and give him 10, 15, 30 days, depending on the contract, to go ahead and cure that error, and then if not, to terminate. So when you're talking about breaching a contract, usually, unless there's specific language in the contract that allows you to do so, then there's really no, rule on what you have to do or what you have to say. If you are going to breach a contract that you've entered that doesn't have a termination clause, or doesn't have an out, so to speak, in the language, then I would definitely recommend that you send your notice of intent to breach as quickly as possible. And you definitely want to outline all of the reasons why you feel that you can't continue with the contract. You might want to include some non-performance on their side, just for viability. As you know, breaching a contract can open you up to liability for that breach of contract. So before you do that, you definitely want to make sure that you have some good, valid reasons that you feel okay defending in front of a potential judge, jury, or arbitrator.
Thank you so much. Ralph asked a couple questions here. He's actually from South Africa, so it's great to have him here and joining us. So he was saying that litigation is very saturated in South Africa. Most construction contracts in South Africa require arbitration as a primary resolution method before court procedure begins. How long is a general litigation process in the USA? For South Africa, it could take nearly over a year.
Well, if we're talking about nearly over a year for South Africa, we've definitely got you beat. It can take up to 3 years in a metropolitan city like Houston. You're looking at 2.5, maybe 3 years, and that's just because the dockets are so full. People are making good money, and people are suing and using it to try to enforce their contracts or defend or collect damages. So I've absolutely seen, at minimum, I'd say 18 months, and that is a very small dispute, most likely under $100,000. But our dispute resolution in the litigation takes about 2 to 3 years at the most. I've seen it go longer, but you're talking about multi-millions of dollars if you're getting up to 4 and 5 years. But absolutely, I agree with you as well. There's some similarities there in that I would say 99% of contracts here in the United States, when it comes to construction, do require arbitration and don't even allow you to start digging around in the litigation process.
Okay. Thank you so much. We have a question here from Chris. Is mediation your most recommended avenue for dispute resolution in matters, and why?
I would say actually my most recommended is informal dispute resolution. If someone can come in and hire me and I can get things resolved off of 3 or 4 letters and picking up a phone call, and conversing with another attorney, that's how I love to do it. No one likes to, charge you guys an arm and a leg, to get matters resolved. Usually when you come to me, you already have a problem. So I would say informal dispute resolution is my favorite. But mediation's definitely my second favorite. I would say, as a practical side though, you want to try to get to a point where you're ready to mediate as early as possible. Mediation can be, kind of difficult if, for example, you've already been litigating for 1.5 years. Maybe you've been litigating 2 years. You've spent a considerable amount of attorney's fees. And, there's a point where you're going to price yourself out of mediation. Right? So, let's say you have a breach of contract, and in the American system, attorney fees are recoverable in a breach of contract. If you start with a $50,000 breach of contract and you rack up $50,000 more in attorney fees and you go to mediation, you have to remember that you're meeting in the middle, right? So no one is going to give you the full 100,000 in mediation, because worst case scenario, a judge and a jury tells them that, and that's not meeting in the middle, right? Getting everything is not generally meeting in the middle. And so I think once you've gone too far, or you've gotten too litigious, sometimes it takes the case out being able to be successfully mediated. And so if I can have a dispute informally, resolved informally with a few demand letters, that's my absolute favorite way. Or at least, getting into litigation and getting a good mediation nice and early, 6 months in, 8 months in, before, we've dragged this on 2 years and nobody's happy about settling. I like to have happy clients at the end of the day.
Definitely. Another question from Ralph: what type of construction contracts are mainly used in the US?
We have, I'm trying to think of the name of, I think it's the Arbitration Association, or no, it's the AMA, I believe, that does the contracts. They're very popular. They're your standard promulgated form. That's just a fancy way of saying that the construction industry has hired some lawyers to come up with one general form that everyone can plug their name, into. They can pull out, and excuse me, it's AIA, not AMA. But they can pull out clauses, they can stick them in. Now, those are very good. I would say you always want to, again, talk to an attorney when you're coming up with your contract. Even if you're going to use a pre-promulgated form, there's still clauses that can be taken out or added in. And so if you don't know what those clauses mean, or you don't know the benefit, well, then sometimes you've added stuff that can be detrimental to you in your contract that may be beneficial to somebody else. So, just that one swing at the bat, again, just like a promulgated form, if you hire an attorney to do your contract, you can still use that same contract throughout the entirety of your business just by changing the names and numbers. You don't have to hire an attorney for each one. But I would say the AIA contracts are pretty much the most standard. And they're extremely general contractor friendly, by the way. Very, very much so.
Another question for you, Aisha: what do you do if you can't get in touch with a contractor to resolve a dispute you have with them or their company?
Well, if you can't get in touch with the contractor, then I would, number one, document your efforts to get in touch, right? You want to try to do a little more than send emails. Typically in a contract, they're going to have an address on the contract, a point of contact. So you want to create a paper trail, send a couple certified letters, obviously the emails, but you definitely want to get some letters going, maybe a couple of phone calls, just document all your efforts. And then, you want to send a termination letter. At that time, if you can't get a hold of them, they're not doing their work, then I would definitely send, maybe a 5-10 day notice. Hey, look, we're going to fire you. We're going to have to hire somebody else. We haven't got a hold of you. And then that way later, if you hire a substitute contractor to perform their work, you can do what's called back charges, right? So you can back charge from them what was owed on their contract for the monies that you had to pay a new contractor to come in and fix and or finish their work. But sometimes contractors unfortunately do run off. We're talking about some people who are small businessmen or self-employed, and so it's definitely not unheard of for a contractor to take your money or sign up with you and basically disappear. It's very unfortunate, but you just want to cover your base. You always want to remember that somebody else might have to decide this dispute. And so you want to look as reasonable as possible. And you always want to, have something you can bring to show them, hey, look how reasonable I was, right? I sent 10 emails, I mailed 2 letters. I even gave them 10 days and asked them to please call me back. And, it makes it real hard to decide against you at the end of the day when you've been reasonable and you kind of got screwed over.
Perfect. Thank you so much. Can you talk about how mechanical liens are connected with the dispute resolution process?
Yes. So mechanics and materialmen's liens are pretty much connected to litigation, right? They're not going to be, they're not going to have too much of a direct line to mediation, arbitration. You can absolutely resolve one with an informal dispute process. A few demand letters. Lots of times, once a person gets a lien on their property, now they're ready to come up with some money. But other than that, your only remedy to enforce a lien is going to be to foreclose the lien. And that is the judicial process. That is requiring litigation. That means you have to file your petition with the court and ask them to foreclose the lien. And so I would say that mechanics and materialmen's liens are heavily tied to litigation, although they can be informally resolved just like any other dispute.
Thank you so much. We had a question from Chris. Do mediators have to have a special qualification, or can attorneys mediate where desired?
Well, here in Texas, now, unfortunately, I can only speak about Texas. This is where I'm licensed, and so I'm most familiar with the rules here. But in Texas, they do have to have 30 hours of mediation training in order to do that. There are other areas of the law, for example, family law, where they have to have additional training hours specified for that. But once you've obtained your 30 hours of training, you can feel free to mediate any disputes. I think the most important way to vet your mediator is by word of mouth, right? Lots of times attorneys know who the good mediators are in town. You want to ask your attorney. Typically they confer with opposing counsel, they come up with a list and they meet somewhere in the middle on, people on that list. So we prefer to use mediators that are well-versed in construction law, mediators that we have used before, and mediators we feel really will give us a good idea of what's going on. Your mediator is important for them to be knowledgeable, because that knowledge that they have, it can bridge the gap between the parties, right? If somebody's case is really bad legally, they may not succeed in court, and sometimes their attorney has not explained that to them clearly, and the mediator can come in and say, hey, look at these cases that happened before you with these exact same facts. These people weren't too successful. Maybe you should think about resolving this dispute or coming down on your numbers a bit. And so yeah, as far as requirements, you do have to be an attorney. That's definitely hoop number one, and you do have to have the 30 hours of training.
Okay, perfect. Thank you. Pete asked a question: what range of costs for just the beginning, kind of the initial process of informal dispute resolution? Not necessarily that fixed cost, but just kind of a range to expect.
I would say, as far as informal dispute resolution, you're looking at anywhere from $1,000 to $2,000. And this is not necessarily discussing the retainer, right? So most attorneys, including our firm, operate on a retainer. And what that retainer does is it's held in trust, and it allows you to secure the services of that attorney. So retainers are usually refundable. Either you refunded the whole retainer and you're billed on your credit card, or some attorneys actually bill from the retainer, and then once it's zeroed out, they require for you to give them a new retainer. So for example, with our firm, we start with a $2,500 retainer. We generally do not bill against the retainer. That just sits in the trust account to be held, and your credit card is billed. And so where I'm coming up with the $1,000 to $2,000 number, I'm just talking about generally attorney time. Okay, you have to remember attorney time is pretty expensive. Attorney time can range anywhere from $200 for a lesser experienced attorney, all the way up to $400 or $500, depending on what kind of experience your attorney has. And so they bill on an hourly rate, and you can imagine that drafting a letter may take an hour. It may take an hour and a half. Once the letters go out, sending emails back and forth with counsel, that may, over the course of a week, take another half an hour to an hour's worth of time. Once that's all done, when you resolve the dispute, then you're going to need releases, right? We're talking about another hour and a half, possibly 2 hours, to not only draft the releases, but then send those releases over to opposing counsel, who's going to, maybe have his edits or his changes. And so it can go up considerably. If you're talking about a more experienced attorney, it can also go up if opposing counsel, wants to negotiate the release for 2 weeks. You know what I'm saying? But as you can see, it's all based on the time. And so that's why I say it's your cheapest resolution form, because if it's going to take me all that time to do that, imagine the time it's going to take an attorney to draft a petition, to read your file, to come up with questions, to answer them, to petition the court, if they don't get the right answer. or, just to sit in a mediation. Your mediation is 4 to 8 hours, just to sit there for 4 hours, right? So that the time could have been spent on an informal dispute resolution, and, you could come out cheaper.
Thank you so much. We had a question from Brandon that just came in. Is a recorded phone call with a contractor admissible evidence in a legal case?
Well, again, that's going to depend on what state you're in. Every state has different recording laws. Texas is what we call a one-party state. And so as long as one party to the recording is aware that it's being recorded and consents to the recording, then you're perfectly fine. And that one party is you, right? And so if you're recording and it's being recorded and you're perfectly okay with that, then you don't have to disclose to another party that you're recording them, and you can absolutely use that in court. So the answer is yes.
Perfect. Thank you so much. Kind of going back to the AIA documents, are those generally recommended, would you say?
Yes, I mean, I don't have any issues with the AIA documents. I do, they tend to be a little more friendly to the general contractor, but please don't be alarmed by that, because in all honesty, almost all contracts in the construction industry are going to be more friendly to a general contractor than they are to a subcontractor, and as the chain goes down. With that said, they're very good documents. They are drafted by a team of attorneys in the AIA. I just think that it's important that you use those documents as well as you can, right? Because like I stated before, those are malleable documents. There are clauses that can be taken out and put in, and they give you probably about 200 clauses, and some people just leave them all in. Some people take out ones that they may not feel applies to them. But if you don't know the legal ramifications or the legal applicability to those clauses, then you might as well just be writing a contract yourself. You're not really getting the benefit if you don't know what's going on. And so even if you choose to use an AIA agreement, still to take the time to consult with attorney, maybe just pay that 1 hour consultation fee to figure out what clauses you should leave in, right? That's not a lot of work for an attorney. I don't have to draft the clauses. I just have to ask you what your business is about, what your goals are, and then check a few boxes and let you know what clauses to leave in. So they're great contracts. Just try to be knowledgeable of what you're leaving in and what you're taking out.
Perfect. Thank you, Aisha. And thanks, Randall, for asking that question. Can you talk about the flat rates for contract review, Aisha?
Yes. Now, Lay might correct me if I'm wrong. I don't work in accounting, so I'm not too great on our pricing. I know my billable rate, but I think our contracts are $1,500 if I remember correctly. And it's a flat fee. Now, what we do again is we discuss your business needs with you, and then we just come up with a contract that's going to be best to suit your business needs. So that not only includes the consultation as far as what you need and the drafting of the contract, it also includes a second consultation where I will discuss the contract with you. I will go over the applicability of all of the clauses. And so again, you're getting this contract in a electronic format in Word, and then also in a paper format. And so just because I wrote the contract doesn't mean that for certain situations you can't go in there and take out certain clauses. At the end of the contract package, you're going to know what every clause in that contract means. You're going to know if it's applicable to your next situation or not, or if you want to leave it in, if you want to take it out. And then also it can address concerns. A big concern for a lot of people is collecting their attorney fees and costs. And in America, unless your cause of action or your contract says you get attorney fees, then you have to pay your own. And a lot of people just don't think that's fair, because, they go through all this trouble and they sustain damages, and then they have to go pay a lawyer thousands of dollars to collect the damages. And then sometimes, you have to do that cost benefit analysis. Whereas if your contract is prepared for that and protected you for that, you don't have to worry about it. There also are other things that come up in a contractor subcontractor relationship or owner GC relationship that maybe you're not thinking of. It's just so many things that a contract can protect you from, and benefits it can give you. It's really important to do that. And so again, our contract process is $1,500 flat fee, and we'll draft any type of contract that you'd like for your business. I believe we offer employment contracts. I personally don't do that, but we do have employment specialists here in the office that do. We also can offer owner to GC contracts, GC to subcontracts. And again, these can be used across multiple practices, multiple business transactions. And so that one cost can set you up for the entirety of your business.
Perfect. Thank you. And we did some research here, and so I do have the flat rate. So up to 15 pages and an hour and a half client meeting, that's going to be $550. And then up to 30 pages and 1/2 an hour client meeting, that's going to be $1,000.50. And then for the construction contract creation, the flat rate, that is that subcontract agreement, it's going to be $1,500. The residential remodel repair contract is $1,500 as well. The master subcontract agreement will be $2,500, and the residential new build contract will be $3,000, in addition to the general contractor agreement, which is also $3,000. So.
And just for a little further explanation, the 15-page and the 30-page contract, those aren't for drafting. Those are actually for contract reviews. And so, for example, like if you're coming in with your AIA agreement, it's 15 pages. That's how much it is for us to go over the agreement with you, review it, tell you what your clauses are, which ones you can take out, leave in, that kind of thing. And so, you know, those are services that we offer here as well.
Thank you so much.
I just want to say thank you to both of you. Thank you so much for a very informative presentation. That's enriched me. So thank you very much.
Well, thank you. You have a great day.
We hope you all have a great day. Thank you so much for joining us today. We really appreciate it. I'm actually going to send Aisha's contact information here. So if you guys have any other questions, please feel free to reach out. We definitely want to thank you for joining us and spending your afternoon with us. And if you have any questions, just please feel free to follow up with us. And
see you at the next
Aisha,
one.
thank you so much. Yes, please. Thank you all. We hope you join us for our next webinar. And Aisha, thanks so much for your time. We really appreciate it.
You guys take care. Feel free to call me with any questions or concerns.
Thank you. Really appreciate it all. All right. Bye-bye.